So I'd like to introduce you to Beena Patel, a senior associate in the employment team, Emma Fowler, an associate in our immigration team, and me, I'm Nikki Southern, a partner in the employment team. We're also joined by Nadia Zikovic, an associate in our employment team, who's going to be in control of the slides, and we'll be running the Q&A session at the end. So over the last couple of months, we've seen a gradual lifting or relaxation of the coronavirus lockdown restrictions, and this has resulted in a return to work and the workplace for many. Whilst this is generally a positive development, employers are facing a number of challenging problems, in particular managing a safe return to the workplace and the need to take action affecting employees in response to current or future likely financial difficulties. None of us can predict what the future holds, so advanced planning and preparation is going to be key to navigating the evolving COVID-19 pandemic. Employers will need to reshape their organisations and adapt employment relationships to cope with the new reality whilst minimising legal risks. So today, we're going to be starting by considering the legal issues regarding return to the workplace, then move on to the tapering and eventual closure of the furlough scheme, changing terms and conditions of employment, redundancy, and finally alternatives to redundancy. And Emma Fowler will be adding insight from an immigration law perspective through the session. So, starting with return to the workplace. In most, if not all cases, it just won't be safe for employers to open the workplace and for employees to simply return to work as before. As we all now know, common features of the pre-pandemic office now pose obvious risks. So things like hot desking, sharing office equipment, packed lifts, and shared spaces like kitchens or breakout rooms. So the main problems for employers are how to safeguard the health and safety of their employees, clients, and others in accordance with their legal obligations, and also how to go about bringing employees back to the workplace. The situation isn't helped by the fact that the key reference point for all of this, the government guidance, keeps changing, and that guidance can differ depending on the nature of the business. So before we look at the practical steps and issues, it's just worth noting in headline terms where employers' obligations in this area come from. Employers are required to comply with health and safety legislation, including the Health and Safety at Work Act 1974. They have a common law duty to take reasonable care of the health and safety of employees, and they're required to comply with the implied duty to maintain trust and confidence between employers and employees. Failure to comply with these obligations can result in criminal prosecution, up to and including corporate manslaughter, as well as civil liability. So I'm sure many of you will have had your heads in the government guidance for many months now. The Department for Business, Energy and Industrial Strategy, BEIS, has issued 14 sets of guidelines covering a range of workplaces. Employers should keep reviewing the government guidelines, as we all know it changes regularly, relevant to them, and amending their plans, policies, procedures and communications with staff accordingly. Other sources of guidance include Public Health England, the Health and Safety Executive, ACAS and relevant sector-specific bodies. Last night, BEIS withdrew its 5 steps guidance on returning to work safely. So that covered things like carrying out a COVID-19 risk assessment, developing hand washing procedures and so on, but the 14 sets of guidelines remain in place. It's really worth remembering that the guidance is not the law on health and safety at work, so it doesn't replace the statutory and common law duties that employers are under to assess the risks in their business, set up a safe system of work and implement that system. And these duties may in fact not be fully discharged by complying with the guidance. So what does all of this mean in terms of what employers should be doing and the potential practical issues that may arise as they prepare to open up their premises and have staff return to the workplace? So first up is a risk assessment. Many of you will have already conducted risk assessments in respect of your workplaces. But if not, consider doing this with a health and safety specialist involved. It's obviously no ordinary risk assessment and it's worth investing in getting it right. Government guidelines state that employers should share the results of the risk assessment with their workforce, and if they have over 50 workers, they ought to be publishing it on their website. Once the assessment has been done, Think about whether all staff will be required to return to the workplace, and if not, how the selection is going to be made of those asked to return. Make sure that you have objective grounds for the selection decisions made, which are driven by the needs of the business and take into account the health and safety risks identified in the risk assessment. It's very important to avoid making assumptions that may be deemed discriminatory. So, for example, assuming that employees with small children wouldn't want to return to the office or that they would. Once you've made your selection decisions, document them. The next step is to put policies in place and implement those policies or update existing relevant policies to take account of the measures you'll be introducing in light of the risk assessment and guidance. Having clear policies in place helps to demonstrate that you've complied with your health and safety obligations, although obviously key to that is the effective implementation of those policies. Provide training on any new rules or policies and take steps to ensure implementation, including sanctions for non-compliance. Keep policies under review and consider making changes if necessary. Importantly, consult with employees about the return to the workplace and the measures you'll be putting in place. Many employers have used surveys to do this, so seek views on the intended or proposed changes to the workplace, evaluate the responses and communicate what the business intends to do in response. So what kind of issues will we be looking at going forward? One of the biggest, I think, is going to be managing employees' concerns about the return to work. Consider having a dedicated member of the HR team or management to act as the key point of contact for employees who may have concerns about returning to the workplace or concerns following their return. Keep communication going with employees. If people have concerns, consider them and what you can do to address them. Travelling to and from work is a big one. It's going to be a key point of concern for workplaces where most of the employees travel using public transport. Consider what can be done to your premises to facilitate or accommodate other modes of travel. So, for example, expanding facilities that would assist cycling or running to work, for example. And if employees are not comfortable travelling to work, consider whether they can continue to work from home. Childcare responsibilities, another big one. Lots of children have obviously returned to nurseries and school now, but there is less childcare available. Many schools are not providing wraparound childcare, and there is always the risk that obviously if there are cases of COVID, that nurseries or schools will close. You should discuss individual circumstances with your employees fully. What is the issue with the childcare and how long is it likely to last? You could offer parental leave, dependence leave, or potentially a flexible working arrangement, such as reducing working hours or days of work to deal with the difficulties that employees face. Check the policies you have in place and provide them to the employee. Where an employee has exhausted all of their statutory and contractual entitlements to leave and they still can't work due to childcare, then it may be open to the employer to dismiss the employee for capability reasons or some other substantial reason. But you should tread very carefully in doing so. I would recommend that you consider all alternatives first, including prolonged unpaid leave or a sabbatical. And care must be taken not to discriminate, including in any decision to dismiss. Remember that working arrangements are likely to constitute PCPs, so a provision, criterion or practice, which may particularly disadvantage an employee as a member of a protected group, and so may amount to indirect discrimination, which needs to be justified. You should make sure you keep a contemporaneous record of all communications with the employee, agreements made with them, and the rationale for all decisions taken. In respect of those that were previously shielding, vulnerable, or are disabled, special consideration will be required. So shielding was paused from the 1st of August this year, which means that in principle, those employees can return to the workplace as long as it's COVID safe, but they should continue to work from home wherever possible. Remember that in respect of disabled employees, employers have a duty to make reasonable adjustments to avoid them being placed at a disadvantage compared to others. And this could mean making adjustments if an employee's disability means that he or she is at greater risk from COVID-19. Also be aware of vulnerable employees. By that we mean pregnant employees over 70 or those with pre-existing underlying medical conditions which put them at greater risk. The best course of action, as I've said, is for those employees to continue to work from home, although that could be for a long time until there's an available vaccine or effective treatment for COVID-19. If individuals falling into this category wish to come into the office, you will need to discuss how that can be done safely. Consider agreeing a return to work plan with them, which takes account of your policies in relation to COVID-19 and any necessary adjustments to enable their return. Continuing to exclude people falling into these categories from the office could in itself give rise to allegations of discrimination. So it really is worth trying to work out how they can return to work safely. Refusal to return to the workplace is something that employers will increasingly, I think, have to deal with. So this would be the case where employees refuse to return to the workplace even after you've taken all the necessary steps under the guidance to make the workplace as COVID safe as possible. If you require an employee to come back to work or you dismiss them, the business may be at risk of claims for unfair or constructive dismissal, whistleblowing and discrimination, particularly in respect of those considered to be at risk of greater impact of COVID, such as those of African or Caribbean backgrounds or employees with particular disabilities. If an employee refuses to attend work because they reasonably believe that there is a serious and imminent threat to their health at work or during their commute, which can't reasonably be controlled by the employer, and the employer terminates employment because of their refusal to attend work, or the employer insists that the employee attend work and the employee resigns in response and claims constructive dismissal, their dismissal would be automatically unfair on the grounds of raising concerns about health and safety. There's no minimum service requirement, so there's no need for the 2 years qualifying service that is typically the case with unfair dismissal claims. And the compensation that can be awarded is uncapped. And it is likely that coronavirus will amount to a serious and imminent risk. If, on the other hand, you feel that an employee is unreasonably refusing to return, you could consider formal disciplinary action and possibly dismissal, but it is advisable to consider other alternatives first, given the exposure to possible claims, however unmeritorious. One alternative is to require the employee to use their remaining annual leave entitlement, followed by a period of unpaid leave. But given that we really don't know how long this situation is going to continue, this may not be acceptable to the business. And just on a final point, don't forget those that are working from home. It is likely that many of your employees will continue to work from home, at least on a part-time basis. So keep regularly checking in on their health and welfare. The Health and Safety Executive has just issued guidance. There's separate guidance for employers and employees on lone workers. So those that are working alone, including from home, without close or direct supervision. It considers stress and other health factors, managing the health and safety risks of working alone, training, supervision, monitoring, and work-related violence. It's definitely worth a look. So I'll just hand over to Emma now.
This is the first immigration considerations slide. At the end of each employment section, I'll touch upon the immigration considerations for the points just covered. Here, to set the scene, I'm going to briefly speak about the general immigration impact of working from home and COVID, including right to work checks, the employer checking service, and sponsor duties of tracking and reporting. First, right to work checks. For many of my comments later, they will apply primarily to sponsor license holders with sponsored temporary workers. However, right to work checks apply to all of you as UK employers. They're also known as prevention of illegal working checks and apply to any employer, whether or not you have a sponsor license. The right to work regime has remained in place throughout the pandemic. Employers have continued to be obliged to check suitable right to work documents for employees before they start work. This is usually either an online check or more likely a check of certain specified physical documents. For people who would usually need to be seen in person with their original documents, there has been a coronavirus concession from UK Visas and Immigration that has allowed the right to work check to be carried out remotely and with scanned documents, rather than the usual need to do it in person with originals. Any right to work check carried out under the coronavirus concession must be repeated in person within 8 weeks of the concession being removed. At present, the concession is in place, so there's no deadline as yet to carry out these repeat checks. The 8-week countdown has not yet started. However, if employees are starting to return to the office, employers will need to consider whether they want to get a head start on these repeat checks, perhaps just on those people who are happy to attend the office for now. Similarly, for those new starters who may be joining with a mix of work from home and in the office, employers should consider whether they would rather use the coronavirus concession, which requires a repeat check in the future, or the standard in-person right-to-work check from the beginning. I'll touch now on the employer checking service. Employers who usually support priority applications for their sponsored workers or for other employees with a visa may be finding for the first time that the biometric residence permit copy or other evidence on file has expired, but the employee's application is still under review. Since the beginning of lockdown, the priority service for applications in the UK has been unavailable. As such, applications are taking several weeks or several months to be concluded, rather than the days or weeks that we were used to in the past with priority services. In this case, as long as the application was made before the visa expired, the employee's right to work should continue. Employers must follow specific steps and satisfy themselves that an application was made on time, and then obtain evidence from the employer checking service of that fact. Employers should ensure they are familiar with the employer checking service provided by the Home Office, which can confirm an employee's right to work in these circumstances. Sponsor duties of tracking and reporting are also important considerations at this time. Sponsor licence holders have an obligation to track, in relation to their sponsored workers, absences and contact details. Employers need to ensure they have robust systems in place to record relevant information and pass that information internally to the required member of staff responsible for the sponsor licence. These tracking and reporting systems may need to be reviewed to provide contact with employees who continue to be based away from the office for long periods. Throughout this recent period of work from home, UKVI has confirmed that Tier 2 sponsored workers who are temporarily working from home due to COVID can do so without the need to make a report of this fact to UKVI. We will look later at the required steps if work from home arrangements are made permanent. And I'll pass back to Bina now, who will speak about furlough.
So many of you will be familiar with the furlough scheme, which began on the 1st of March. It's aimed at incentivising employers to retain employees on paid temporary leave, known as furlough, rather than making them redundant. Around 2/3 of British businesses have been using the scheme to support around 9.6 million jobs. Information on the scheme can be found in various Treasury directions and government guidance, and further details are set out in the slides. Whilst the scheme has been a lifeline for many businesses, it has started to wind down and it will eventually come to an end on the 31st of October. From the 30th of June, the scheme became closed to new entrants. And from the 1st of August, the scheme introduced incremental reductions to the amount that employers can claim from the government and required employers to begin contributing to the scheme. So you'll see from the next slide that under the original scheme, eligible employers were able to claim 80% of the wages of its furloughed employees, capped at £2,500 per month per employee, as well as employer NI and statutory minimum pension contributions in respect of each furloughed employee. And employers were not required to pay anything. However, from the 1st of August, employers became liable to pay the employer NI and pension contributions going forward. And since the 1st of September, employers are now only able to claim back 70% of wages, and they're having to pay the remaining 10% to ensure that employees still receive the full 80% of their furloughed wages. And then finally, from the 1st of October until the closure of the scheme, employers will only be able to claim back 60% of wages and will have to make up the remaining 20%. While employees can continue to be on furlough until the end of October, the winding down of the scheme and employers' increased contributions to it will clearly add to the financial burden for many businesses. To soften the blow of the imminent closure of the scheme, the Chancellor has announced a new jobs retention bonus to provide further financial support to employers. It's aimed at encouraging employers to retain furloughed employees until at least the 31st of January 2021. The bonus is a one-off payment to employers of £1,000 for each retained employee. In order to be eligible, employees must earn above the lower earnings limit and not be serving out a notice period that started before the 1st of February 2021. Payments will be made to employers from next February onwards, and further information on the bonus scheme can be found on the government website, and full guidance is expected by the end of the month. So, flexible furlough. This is another key feature of the revised furlough scheme, and it introduced flexible furloughing from the 1st of July. This was introduced to allow employers the flexibility to bring furloughed employees back to work for any amount of time and any work pattern. Previously, employees had to be furloughed for at least 3 consecutive weeks. So, depending on the needs of the business, employers can therefore keep furloughed employees on furlough or return employees on furlough back to work. And it's important to ensure that any required notice is given to employees in accordance with any furlough agreement to end furlough. Or furloughed employees can be returned to work on a part-time basis. In other words, require employees to work some of their normal working hours and be furloughed for the rest. And this can help with phased returns back to work. Or employers can unfurlough and refurlough employees on rotation. Any flexible furlough arrangements must be agreed in writing with employees. Agreements can last any amount of time and can be entered into more than once, and copies of any agreements should be kept for at least 5 years. In respect of the payment to employees who are flexibly furloughed, they should be paid in full for the hours they work, and employers can claim the furlough grant for any hours which employees are on furlough. As with all other decisions, employers should ensure that any decisions in respect of furloughing staff are made objectively and in a non-discriminatory way, particularly if that involves rotation or unfurloughing some staff and not others. And before we finish on this topic, I just wanted to touch on furlough fraud. You will know that staff should not be required to work for the employer whilst they're being furloughed. However, there have been recent reports of employers claiming furlough payments but requiring furloughed employees to work in breach of the rules or failing to pass on the furlough payments to employees. The first arrest for furlough fraud was reported in July of an individual allegedly committing a fraud amounting to almost £500,000. And it's also been widely reported this week that up to £3.5 billion in furlough payments may have been claimed fraudulently or paid out in error. The government has now passed the Finance Act 2020, which came into force on the 22nd of July to address this. This provides HMRC with enforcement powers to recover monies from a business where it's proved that a furlough claim did not meet the strict criteria set out under the scheme. In other words, employers can be required to repay the furlough grant in the form of a tax, plus a penalty of up to 100%. Employers, however, will be provided with a limited grace period to review and check the validity of their claims. If an error is found, they should notify HMRC and they could avoid a penalty. Details of the 90-day grace period are set out in the slide. Essentially, this provides that if you come forward within the grace period about any furlough payments you should not have claimed, you will still have to repay the furlough grant but would escape the penalty. If you own up after the grace period, the penalty will be payable, but it can be reduced. But if you know you received a furlough payment you weren't entitled to and failed to own up, this will be treated as a deliberate and concealed failure to notify, and it'll be subject to a penalty of up to 100% of the tax. This means that you could end up paying double, which is the original amount of the grant plus the same amount by way of penalty. Criminal prosecution is also likely to be considered if an organisation fails to comply with a direction from HMRC to repay the furlough grant. So in conclusion, it's advisable to start preparing for the closure of the furlough scheme as early as possible and consider what plans you have for your employees once it's closed. Now back to Emma.
Happily, there's little to add from the immigration side. Those of you who hold a sponsor licence and have sponsored workers will already be aware that Tier 2 sponsored workers were permitted to have their hours and pay reduced temporarily in line with the furlough provisions, even where such reductions would otherwise have been prohibited. Special coronavirus guidance from UKVI allowed these reductions as part of a company-wide policy where all workers, sponsored or not, were treated the same. As the furlough scheme comes to an end, UKVI will no doubt expect Tier 2 workers to return to their usual work pattern and salary in line with other members of staff. We await an update from UKVI with any specific guidance as to the end of these arrangements and whether anything special will need to be done for sponsored workers. Now I'll hand back to Nikki.
Thanks, Emma. So now we're going to look at changing terms and conditions. Sadly, lockdown and the looming financial crisis means that many businesses will have to put cost-cutting measures in place if they haven't done so already, particularly as the furlough scheme comes to an end. And there may be other changes to terms and conditions that employers need to make to ensure terms reflect what is required of employees both now and potentially in the future. So what kind of changes might you be looking to make? The obvious one is a reduction in pay and potentially hours. A reduction in pay is likely to be more palatable if it's accompanied by a reduction in working hours, but it may be that the needs of the business will mean that this isn't possible. When changing terms, consider whether any reduction in pay or hours should be temporary or permanent. If it's going to be temporary, introduce a review period of, let's say, 3 months. And moving from a temporary change, so I know that there were temporary cuts in pay over the last few months. If you're moving from that being temporary to permanent, make sure that you get further consent. In terms of the reduction in salary, there is likely to be a knock-on effect on other employee benefits, such as pension, life assurance, bonuses and commission, redundancy pay, notice pay, and in respect of hours of work, also an impact on holiday. Consider whether or not you can agree certain safeguards against these knock-on effects. So, for example, could you agree that the employee's original salary will be used for the purposes of calculating employer pension contributions, or redundancy pay if redundancy occurs within 12 months of the pay cut? If you're not intending to make changes for all staff, consider the basis on which you will select those that will be impacted. It's really important to make sure that employees are treated fairly, that decisions are transparent, and based on objective and non-discriminatory reasons to avoid claims for discrimination, and in respect of changes to pay, equal pay. It's also worth noting, and probably goes without saying, that junior and mid-level employees are far more likely to accept a pay cut if they can see that those in senior positions are sharing the pain and also taking a cut. Other changes to contracts of employment. So we were all forced, those of us that could, into home working quite suddenly as a result of lockdown. But for many of us, home working is here to stay, certainly on a part-time basis. So consider whether you need to amend the place of work clause in employment contracts to give more flexibility so that you can require an employee to work from home or somewhere else at your discretion within reason. You may also wish to anticipate further lockdown situations or just reductions in work by inserting layoff or short-time working clauses in contracts. These would allow you to put employees on unpaid leave during a temporary diminution of work. These kinds of clauses are typically used in sectors such as manufacturing, but we may now see them used more widely. Many businesses have survived lockdown because of the furlough scheme, but in future lockdowns, if we have them, that scheme may not be available. Again, on the home working front, as many people continue to work from home, you might want to consider updating policies on confidentiality and data protection. And if you don't have these rules in place already, consider introducing rules around all work being done and saved on company rather than personal devices, keeping confidential papers in locked cupboards, and printing, should it be banned, given the potential for confidential information or personal data to be printed out and left in unsecure locations. And we've already talked about changes to rules regarding health and safety. So how do you go about making those changes? The first step really is to consider whether those changes are contractual or non-contractual. Changes to fundamental terms such as pay, working hours or days, role and responsibilities are clearly contractual. Changes to certain policies that employees are required to adhere to, but are stated to be non-contractual, are not. So you have more flexibility with those, although as a matter of good practice, you should seek employees' agreement to those changes as well. And although we're not going to look at this in today's talk, you should be aware that if you have a unionised workforce with collective agreements in place, you can't negotiate changes to those terms on an individual basis. So can the changes be made under the existing wording of the contract? Some contracts contain clauses which, on the face of it, allow for changes to be made without an employee's consent. Those may be changes to specific parts of the contract, such as the employee's responsibilities or place of work, or the right to make general amendments, potentially by giving notice to the employee. Treat these clauses with caution, particularly if the changes you're proposing are significant or detrimental to the employee. Best practice is always to obtain the employee's agreement to the change in question. We're going to have a look at 3 options for changing contracts. The first is unilateral variation. This involves essentially just making the change without consent. So you might inform the employees of the changes and when they'll take effect, and then just make the changes. This really isn't advisable for anything other than minor changes, as it could lead to claims for breach of contract, constructive dismissal for those with 2 years service, and unlawful deduction from wages where the change relates to pay. Written agreement or consent. Consent can be implied. So for example, if you make the changes and the employees continue to work without complaint, potentially there will be implied consent. But the least risky approach is to obtain employees' express written consent to the changes you're proposing to make. So how do you go about getting it? Timing and planning is key. So engage with employees as early as possible to make sure that there's time to deal with individual issues raised about the changes before the date for implementation. Notify the employees. That will involve explaining the changes you propose or intend to make, the reason for the changes, and when you intend those changes to take effect. It's really worth putting some time into explaining the rationale. Most employees won't wish to accept a pay cut, so explaining that cost savings now may avoid the need for redundancies for the time being may help to smooth the way. Once the employees have been notified, you'll need to consult with them individually and potentially collectively if it's likely that the business will be required to terminate employment and offer re-engagement in order to bring in the new terms. Bina's going to have a look at this in more detail. Individual consultation is an opportunity to engage with employees, for them to respond to the proposals, ask questions, and suggest alternatives. Don't forget the paperwork. Make sure that you get written agreement to the changes, ask that employees sign and send back the new contract or the letter varying the terms or the policies. Termination and re-employment, this really should be the last resort. But if employees refuse to accept the changes and you wish to push them through, you could terminate their employment and offer them a new contract with the revised terms to take effect immediately after the old contract terminates. Termination should be on notice to avoid wrongful dismissal claims. This approach would leave you exposed to a number of potential claims, including unfair dismissal for those with qualifying service of 2 years, or potentially a claim for redundancy pay. In terms of procedure, you need to undertake a consultation exercise with each individual to explain the intention to terminate if they don't consent to the changes and obtain their views before terminating their employment. Now I'll hand over to Emma.
From the different possibilities that Nikki's covered, I'm going to draw out those issues that are particularly important from an immigration point of view, namely changes to hours and salary, changes to work location, and the reporting and record keeping impacts of these different changes. Changes to hours and salary. Looking at Tier 2 sponsored workers, in many cases, there's no minimum with regards to contractual work hours. The exception to this is Tier 2 sponsored workers in shortage occupation roles, who usually require a minimum 30-hour work week. For other sponsored workers, the potential to agree a reduction in hours is likely to be guided by whether the related reduction in salary is permitted. There are strict and complex requirements regarding minimum salaries. The relevant minimum salary could be different for every sponsored worker in an organisation, as it is affected by many factors, including the employee's age, length of service, their visa, their role, and contractual hours. It's therefore not possible to make sweeping decisions for groups of sponsored workers. Despite working in the same role on the same salary, there may actually be other factors that dictate different underlying minimum salary requirements. Changing work location. As outlined previously, temporary work from home due to COVID has been permitted without any report required to UKVI. However, now that long-term or permanent changes to the work locations are being considered, you must remember that permanent changes to work locations of Tier 2 employees will need to be reported to UKVI. If a sponsored worker who has been working from home temporarily for a number of months now agrees to a permanent change of their role to work from home, this needs to be reported. UKVI has also explained that it expects an employer to retain a justification as to why sponsored workers need to be based in the UK and hold a work visa if they are working full-time from home and not physically present in an office with their colleagues. The deadline to report a permanent change is 10 business days from the point at which the change became long-term. The justification doesn't need to be shared with UKVI up front, rather held on file ready for an audit. On a related note, if a sponsoring employer decides at any time to reduce the number of physical offices in the UK, perhaps due to continued work from home of much of the workforce, this information must also be reported to UKVI so that the work sites listed on the sponsor licence can be updated accordingly. Thinking about the way in which these different changes can be made, it's important to note that termination and re-employment is not going to be a great option for Tier 2 sponsored workers. Termination would usually require the end of employment to be reported to UKVI, leading to the visa being curtailed, that is cancelled, and potentially then a new Tier 2 application would be required before the employee could be re-employed. Any changes that are made, as well as being reported to UKVI at the time, should be clearly reflected on the employee file in case of an audit. UKVI will want to see that the sponsor has made the changes in a suitable way in accordance with employment law, and that the paperwork on file corroborates the details reported to UKVI, such as dates and details of the changes. I'll hand over now to Bina, who will speak about redundancy.
Thanks, Emma. Unfortunately, the devastating effect COVID-19 has had on the economy and many businesses means that redundancies are likely to be inevitable. Although the furlough scheme has helped businesses to retain staff, many may not yet have recovered financially to be able to take on the additional employment costs arising from the scheme being scaled back and its eventual closure. Sadly, a number of companies have gone into administration whilst others have announced mass redundancies, such as BA, Centrica and Rolls-Royce. Unfortunately, it looks like this could be just the beginning. Employers facing hard times will be under financial pressure to drastically reduce costs and headcount, which will mean redundancies. There are a number of key points for employers to consider to help navigate their way through redundancies and minimise legal risk, including their obligations in relation to unfair dismissal and collective consultation. So, starting with unfair dismissal. Back to basics. In order to minimise liability for a potential claim, employers should ensure that essentially there's a fair reason for the dismissal and they followed a fair procedure. Redundancy is one of the fair reasons for dismissal. So an important starting point is to ensure there's a redundancy situation and the redundancy is the real reason for the dismissal and it's not masking another reason such as poor performance. The legal definition of redundancy essentially covers three scenarios. Firstly, the closure of a business. This is where a business closes down completely and an employee is out of a job. Secondly, a place of work closure, when an employee's job is no longer to be carried out in the place they were employed, such as the closure of a particular branch. And thirdly, where there is no longer a requirement or a reduced requirement for employees to carry out particular work, such as headcount reductions. These will be common scenarios for many struggling companies at the moment, and so establishing a genuine redundancy situation is unlikely to be an issue. Some other substantial reason, or SOSR, is also a fair reason for dismissal, and this is sometimes relied on by employers in respect of a business restructuring or reorganisation where this does not meet the legal definition of redundancy. So what does a fair redundancy procedure look like? Well, this would typically include warning employees they're at risk of redundancy and the reasons for this, having a fair and objective selection process, consulting employees, and searching for suitable alternative employment. Employers should also ensure that they comply with any contractual redundancy terms and follow any internal redundancy policies and procedures. So starting with the selection process. If employees are to be selected for redundancy, such as in situations involving headcount reductions, employers should first identify appropriate redundancy pools from which to select those employees. There are no hard and fast rules in identifying a pool. In deciding which employees to include within a pool, it's helpful to consider what particular type of work is ceasing or diminishing and who carries out that work, and which employees do similar work and whether their skills are interchangeable. Employers will then need to consider the proposed selection criteria against which employees in each pool will be scored and provisionally selected for redundancy, with those with the lowest scores being selected. The selection criteria should be fair, reasonable, objective, and relevant to the needs of the business and the particular redundancy situation. It should ideally be measurable, for example, by reference to employment records, such as performance reviews. Examples of potentially fair selection criteria could include things like performance, experience, skills, and disciplinary records. And employers should avoid any potentially discriminatory selection criteria and making discriminatory assumptions when scoring. So when carrying out the scoring exercise, it's recommended that employers apply a fair and consistent application of the criteria across all employees, that at least 2 managers separately undertake the scoring for each employee to ensure objectivity, that the scores are able to be justified and independently verified, where necessary, reasonable adjustments are made for disabled employees, that accurate records are kept of the basis for the scoring, and that employees are consulted about their scores and given an opportunity to challenge them. Next is consultation. A fair, proper, and meaningful consultation process should be carried out with affected employees when the redundancy proposals are at a formative stage, with an open mind and before any final decisions are made. Employees should also be provided with sufficient information about their proposed redundancy on which to respond and within a reasonable time frame. The types of things that employees should be consulted about include the reasons for the proposed redundancy, the basis for their selection, including their scores, ways of avoiding the proposed redundancy, consideration of potential redeployment, and employees should also be allowed to raise any other matters and ask questions. The employee's views and responses to the consultation should be properly and genuinely considered and responded to by the employer. Finally, employers should also make reasonable efforts to search for suitable alternative employment for employees at risk within their own organisation and, where possible, with associated employers, and provide any relevant information about vacancies to employees. If there's more than one at-risk employee interested in the same alternative vacancy and role, the employer should act fairly and reasonably in deciding who gets that role. For example, by carrying out a competitive interview process for the role, unless a potentially redundant employee is on maternity or adoption leave, in which case they should automatically be offered any suitable alternative vacancy. Next, I wanted to touch briefly on collective consultation. This is triggered if 20 or more redundancies are being proposed at one establishment within a 90-day period, and in which case an employer will need to undertake collective consultation. We may well now see many more employers having to engage in collective consultation, including smaller businesses, due to the pandemic. The Insolvency Service should be notified of potential redundancies by submitting a HR1 form at least 30 or 45 days before the first dismissal, and failure to do so could result in a criminal offence. The government has issued a new HR1 form with new guidance notes, which is available on its website. So, timing and length of consultation. Consultation should begin in good time, and in any event, where there are less than 100 proposed redundancies, at least 30 days before the first dismissal takes effect, and where there are 100 or more proposed redundancies, at least 45 days before the first dismissal takes effect. Although this means that notices of termination could be issued during the consultation process, as long as the dismissals don't take effect until the end of the process, before the process, it's advisable to wait until after the consultation period has ended to avoid arguments that the consultation was not meaningful or ended prematurely. So who should be consulted? Well, collective consultation must be with appropriate representatives. This means either trade union reps, if there's a recognised trade union, or otherwise employee representatives. And employers should arrange elections for employee representatives if necessary, and there are detailed rules on how this should be done. Excuse me. Employers will also need to provide certain written information to the appropriate representatives as part of the consultation process, and details of this information are set out in the slide. So what kind of consultation should be carried out? Well, the matters employers must consult on include ways of avoiding the dismissal, reducing the number of employees to be dismissed, and mitigating the consequences of the dismissals. Consultation must be meaningful, undertaken with a view to reaching agreement, and take place when the proposals are still at a formative stage. And collective consultation should not be a substitution for individual consultation, which should also be carried out. But what happens when things go wrong? Well, failure to comply with the collective consultation obligations can lead to potential claims for protective awards of up to 90 days actual gross pay in respect of each affected employee. There is, however, a limited defence available to employers who do not comply with certain collective consultation obligations, and this is referred to as the special circumstances defence. This applies where there are special circumstances, which would mean that it's not reasonably practicable for an employer to comply with certain requirements. However, it's still advisable for employers to take reasonably practicable steps towards compliance where possible. So, where redundancies have been confirmed, it's important to ensure that employees receive all statutory and contractual payments and benefits to which they're entitled on termination, such as holiday pay, bonus payments, and notice pay. Employers should check employment contracts and relevant policies for these, and consider whether there are any express enhanced redundancy terms, or whether these may have been implied by previous custom and practice. In respect of any notice payments, employees with normal working hours should be paid their statutory notice pay at their normal rate of pay, rather than any reduced furlough rate. And this also applies to any statutory redundancy payments, subject, of course, to the statutory weekly cap. I'd also advise that any enhanced redundancy terms are offered to employees, subject to them entering into a settlement agreement waiving their potential claims against the employer. So hopefully the steps I've outlined should minimise any potential legal or other risks for employers in carrying out redundancies. A redundancy fact sheet has recently been produced by the DWP, which should also assist employers. And this includes details of a rapid response service that employers can use for further guidance on redundancy. Now back to Emma.
Employers should keep in mind that a Tier 2 sponsored worker not only loses their job in case of redundancy, but their visa will also be curtailed so that they have potentially only 60 days to find a new job and make an application with a new sponsoring employer or on some other basis, or to leave the UK. During the consultation process, you should be mindful of this huge impact on sponsored Tier 2 employees and the time pressure these employees would face to find a new sponsored role if they are made redundant. Employers should think carefully about when they might want to raise these immigration issues with their at-risk employees, and also consider whether it may be appropriate to offer support by providing access to immigration advice as early as possible. Tier 2 sponsored workers approaching completion of 5 years in the UK will be particularly sensitive to a risk of redundancy. This is because an application for indefinite leave to remain, permanent residence, can be made after 5 years in the UK with a Tier 2 visa. However, that application must be supported by a letter from the sponsoring employer confirming, among other details, that the role and salary in question will continue for the foreseeable future. Certain caveats to this have successfully been used in letters in the past, and each case will need to be considered individually. However, if the employer is unable to provide a suitable letter, perhaps because the sponsored worker's role is to end imminently, or else because it is at risk of redundancy, then the employee will be unable to apply for indefinite leave to remain. This naturally has a huge impact on their overall immigration position in the UK. Ultimately, if a Tier 2 sponsored worker is made redundant, this must be reported to UKVI within 10 business days. Veena will now speak about some ways to try and avoid those redundancies.
So whilst redundancy is one option for reducing employment costs and headcount, there are a number of alternatives employers could consider to retain skilled and experienced staff, do what they reasonably can to avoid redundancies, be seen to be acting fairly and looking after their staff, and to avoid the negative impact on staff morale that compulsory redundancies could result in. Redundancies should therefore not be a knee-jerk reaction and should ideally be considered as a last resort. So what are some of the alternatives to redundancy? As Nikki mentioned, employers could make reductions to employees' pay, benefits and/or hours on a temporary or permanent basis. Pay freezes could also be implemented going forward. Reducing or banning paid overtime may also be an effective way to reduce costs, and the reasons for this should be communicated carefully to staff, particularly those who have come to rely on additional overtime pay. Agreeing unpaid sabbaticals, career breaks or other unpaid leave can also be a good way to save salary costs for a fixed period of time whilst retaining valuable staff. Also, temporarily seconding staff to other companies where their salary is effectively covered by the third party could also be another option. Offering early retirement could result in vacancies becoming available, which could then be offered to employees who might have otherwise been at risk of redundancy. Freezes on external recruitment could also be put in place, and where possible, existing employees who might have otherwise been at risk of redundancy could be redeployed to fill any internal vacancies. Or if someone's left, a decision could be taken not to replace them, and their work could be redistributed among existing staff. The use of contractors or agency staff could also be reduced. In respect of any potential new joiners, a new start date could be agreed to defer new employment costs, or more drastically, a job offer could be withdrawn before it's accepted to avoid any new costs altogether. Redeployment and retraining is another option, and this is, for example, where one area of a business is busier than another. An employee with transferable skills could be retrained to take up a new role in the other areas of the business. Volunteers for job shares could also be sought, where two or more employees could be splitting a part-time role, a full-time role between them without letting anyone go. And then finally, seeking voluntary redundancies is also another option. With any of these alternatives, care should be taken to avoid exposure to legal claims. And as Nikki mentioned, you would need to consider carefully whether any of these alternatives would involve a change to the terms and conditions of employment, how such changes could be implemented, and in any event, a lawful process should be followed to minimise legal risks. Emma also has a few words to say about this.
While you will naturally want to make every effort to avoid redundancy, it's important to keep in mind that some of the alternatives set out by Veena can be very difficult or else impossible for Tier 2 sponsored workers. As discussed earlier, reduction to hours themselves is not usually restricted, with the exception of shortage occupation roles. However, the accompanying reduction of salary must be assessed very carefully and on a case-by-case basis. There are also strict limits on unpaid leave, typically capped at 4 weeks, although there are exemptions for maternity and related leave or sick leave. Therefore, unpaid sabbaticals are not usually an option for Tier 2 sponsored workers. Thinking about changes to duties and responsibilities, particular care is needed for Tier 2 sponsored employees, whether these changes are by way of reorganisation or taking up an alternative role. If the changes to duties are relatively minor, such that the job type as listed on the certificate of sponsorship and under which the individual was initially sponsored is still the best fit for the new role, then the changes can be dealt with by way of a report to UKVI, and the usual 10 business day deadline applies. However, if the changes are more substantial, so that the new role no longer fits within the same job type as used on the last certificate of sponsorship, then this is not a permitted change. If a substantial change of duties is proposed, for example, retraining and redeployment is explored, it would be necessary to first obtain a new Tier 2 general visa for the worker. This could entail all of the usual processes and may mean that advertising is required for the proposed role. The change to duties would not be permitted until the new application is made. Employers must therefore be very cautious when proposing changes to duties to Tier 2 sponsored workers. The employee's agreement to change is not adequate from an immigration point of view. If an employer inadvertently agrees a change with a sponsored worker that is prohibited by the immigration rules and reported to UKVI, the worker's visa could be curtailed, that is reduced to 60 days. In turn, if the employer's error leads UKVI to question whether the business is able to carry out its responsibilities as a sponsor licence holder, the sponsor licence for the whole business could be at risk. Balance therefore needs to be found between treating sponsored workers in line with others, yet ultimately agreeing changes with Tier 2 workers only where they're permitted by the immigration rules. Any agreed permitted changes will need to be reported to UKVI through the online sponsor management system, as usual, within 10 business days of the change. At this point, I'll hand over to Nadia.
So we're almost out of time for the seminar now, but we will just quickly go through a couple of the questions that you've sent in. So first of all, a question for you, Emma. What is the effect of working remotely on a prolonged basis in a country that is not your normal place of residency and work? What effect will this have on income tax and on creating a perception of a permanent establishment?
So on the face of it, this is a tax question, which is beyond the scope of this talk. It raises questions of tax residency and the potential risk of income tax or social security benefits and liabilities in other non-UK countries, which we can't cover in this webinar. So do take advice on the UK and other countries' side. The idea, however, of working remotely from outside the UK is an important one to keep in mind for employers of Tier 2 sponsored workers. So Tier 2 workers will naturally have family or other ties outside of the UK, perhaps in their country of nationality, and they may have taken advantage of this opportunity to base themselves overseas, or else they could have travelled with an intention to be there for a short period of time, but found it difficult to return to the UK due to self-isolation or travel restrictions. So time spent outside the UK is assessed when Tier 2 sponsored workers apply for indefinite leave to remain after 5 years. And there's usually a strict limit of 180 days outside the UK each year. However, the Home Office will consider granting indefinite leave to remain applications, even if absences are over the limits, if the applicant provides evidence that the absences were due to serious or compelling issues. The Home Office's own guidance says that these may include serious illness or a natural disaster. So although the Home Office hasn't yet confirmed that the current situation is a serious or compelling reason, common sense suggests that it must be. With that in mind, we recommend employees retain evidence of their reasons for working outside of the UK, and employers may wish to provide confirmation in writing to their Tier 2 workers that they approve of this setup. In this way, employees will have some evidence to rely on when the time comes to make an indefinite leave to remain application. But even with this evidence in hand, there would still be a risk.
Thank you. Now we have a question on furlough for you, Bina. Can employers ask people to return from furlough on a part-time basis if they do not have enough work to support them full-time in their particular area of expertise, but want to retain those employees for the longer term in anticipation of work picking up in that area?
Yes, that's one of the reasons behind the flexible furlough scheme. So until the 31st of October, employees can be furloughed on a part-time basis, where they can be required to work some of their normal hours but furloughed for the rest. For example, if an employee normally works Monday to Friday, they could be furloughed Monday to Wednesday and work Thursday and Friday. This part work, part furlough arrangement should be agreed in writing with the employee. You may also want to build in flexibility in the agreement to change this arrangement in accordance with the needs of the business. For example, when work picks up, you could agree to increase the employee's working days. If after the furlough scheme ends, you're still only able to offer part-time hours, as Nikki mentioned, you'll need to consider whether this would amount to a change to the employee's current terms and conditions of employment, and if so, how you'll implement that change, ideally by seeking the employee's written consent to the change.
Thank you. We're out of time now, so I'll hand back to Nikki for the conclusion.
So that brings us to the end of the webinar. We'd like to say thank you very much for attending. We would also like to thank the employment team for their contributions to this webinar. Just to let you know, we'll be sending out copies of the slides and also a recording of the webinar. We hope you found this useful. Goodbye.
Bye.
Thank you. Bye.